case to come before the court is State of Ohio versus Timotheus, Singleton?
I was pronouncing it Timotheus, but honestly, either
Mr.
one
Singleton.
could be the case.
All right, Attorney Rochester, you'll have 15 minutes to present your arguments. You know, stand behind the podium, keep your voice up, and again, there aren't any children, if there's a victim here, please don't mention person by name, and we are ready to begin when you are.
Thank you. May it please the court. I'm Barbara Rogoshevsky, and I'm here today on behalf of Mr. Singleton, the appellant in this case. As this court knows, Mr. Singleton was convicted of robbery, actually in 2016, October 2016, under RC 2911-02A2. In order to be convicted of robbery under that section, Mr. Singleton has the constitutional right to require the state to prove each and every element of that offense beyond a reasonable doubt. This case proceeded to a bench trial. In order to prove this case, the state must have proven the following: that Mr. Singleton, in committing a theft offense, or attempting to commit a theft offense, or immediately fleeing after the attempt or the commission of a theft offense, threatened, attempted, or inflicted physical harm on another person. And then, in order to determine whether the state proved beyond a reasonable doubt that he committed a theft offense, when we look at theft under RC 2913-02, theft requires the following elements: with purpose to deprive another of property, obtain or exert control without consent beyond the scope of consent, by deception, by threat, or by intimidation. That's sort of the Cliff Notes version of theft. So then we have to look at with purpose to deprive. Did the state prove beyond a reasonable doubt that Mr. Singleton had a purpose to deprive another person? And in this case, the item that was taken was a cell phone. Deprive is defined under RC 2913-01C as withholding permanently or for a period that appropriates a substantial portion or value, or with purpose to restore only upon payment or some other consideration, to dispose of so as to make it unlikely to recover, or to acquire with purpose not to give proper consideration. So when we circle back around through all of these definitions, the state had the burden of proving beyond a reasonable doubt that in the commission of a theft offense, he had the purpose to deprive the alleged victim in this case of her property, which was a cell phone. And they have to prove all of these elements in order to have a robbery. I'm submitting to this court that they failed to do so this year.
Well, I was just going to ask, though, he took the cell phone, and I'm sure you can circumstantially reason the reason he took it was in order that you could call the police.
Well, I don't know that we can infer that from the record. There was testimony. There was no testimony that substantiated that he was attempting to take the phone so she could not call the police. In fact, this brings me to an important point that we mentioned in the brief. And that, again, focusing on the purpose requirement of theft and then, of course, robbery. Mr. Singleton was interviewed. And there was also testimony by the alleged victim in this case. And at no point, either in the interview, which was submitted as an exhibit in the trial, and that is available to the court, or the testimony, was the state able to establish that Mr. Singleton knew that the phone he grabbed off the porch after the scuffle was in fact not his phone.
It was my understanding, either from the briefs, let's say, or from recollection from last time, but I'm not sure my recollection's all that good, that the phone was in her hand and came out after the scuffle.
Well, there is testimony that she had possession of the phone at the time of the scuffle. But because there was a scuffle, we can't know that he saw the phone was in her hand. We saw it come out of her hand. What we know is that there was a scuffle and he grabbed a phone. But when the police interviewed him, they never asked him specifically, did you know this wasn't your phone when you picked it up off the porch? They didn't ask him that. If they had, we would have had that definitive answer. But we cannot infer what he knows without testimony or some sort of evidence to establish that beyond a reasonable doubt.
And this is the phone that he bought for her.
According to the record, yes. So again, in order to convict him of a robbery, he has to know it's not his phone, because he has to have the purpose to deprive her of the phone. So that's the first problem with the elements of this case. The other issue is, if you look at the definition of deprive, I think the crux of that whole definition is that there's an intent to keep something permanently or for a substantially long period of time so that the person it truly belongs to loses the value in owning it, or to hold it for some sort of payment like a ransom.
Okay, well, let's go back to, and I know you indicate there's no really any record of that here, that he took it so she couldn't call the police. But let's just assume, because we've had this in other cases in domestic violence.
It wouldn't be the first time.
Yeah, it wouldn't be the first time, that's right. That somebody grabs somebody's phone so they can't call the police. And they hit him and grabbed the phone and ran off. In your analysis, would that not be a theft because it doesn't constitute deprive?
Correct. That's correct. Because when you look at the definition of deprive, and I think the Tench case really sets forth the argument and the elements of a theft very clearly. Just taking something from someone, and with the intent to take it, to possess it for a period of time, does not constitute a theft, because you have to meet the elements of deprive. And under deprive, you have to be able to show that he intended to keep it permanent. And when you look at the facts of this case, I believe the testimony was within approximately an hour. He was contacting her, they were making arrangements to give the phone back to her, and they reconciled. He came back to live there and stayed there until he was arrested. When you look at the elements, there's nothing about that scenario that indicates that he intended to deprive her of the phone permanently, destroy it, hide it so she'd never find it, ransom it off.
Of course, the value of the cell phone is, I know now we use them as a computer, but supposedly the value of the cell phone is to be able to make a call.
It is.
So did you, if you take it from somebody so they can't make their call, is that not in essence destroying the value of the phone at that time?
I read the statute as a substantial portion of the value, meaning that the phone is worth a certain amount of money, and if you keep it for a long period of time or you alter it in some way, it's no longer worth what it would have been worth.
Well, it also has a value in that you can use it for a purpose. Was she injured when they had the scuffle?
I don't know that she required medical attention. I don't require specifically. I don't know that EMS was called or anything like that.
But she was deprived of the use of the phone to be able to call EMS.
At the time, well, she didn't have it in her possession, so no, she couldn't have called EMS. I know the neighbor actually called almost immediately as this was happening. So had they wanted to be called, they could have. Yeah. She herself wasn't in possession of her phone call at that time. No, that's true. I read the statute as the monetary value as opposed to just the mere use of it. And I didn't find any cases that specifically addressed what those words meant.
Well, the value of a phone, wouldn't you agree, is to be able to use it?
Well, the value of anything is to be able to use it. So if
Regardless
you're,
of what the cost is?
well, I agree, but I think when we look at the Tench case specifically says, you know, just because you have it for some period of time doesn't mean it's a theft. Even if, because if somebody has an item for a period of time, the person who doesn't have it can't use it no matter what, regardless of what the purpose is. So I think that's part and parcel. I think you have to prove that there's the intent to deprive the other person of its use for a particular reason. And again, there was nothing to indicate in the record of this case that that was what he was trying to do. And again, we're not permitted to read anybody's mind. The state has to present that evidence. So when we look at all of the elements of a theft and take that back to the elements of a robbery, the fact that that evidence was not presented means that there's insufficient evidence in this case to convict Mr. Singleton as a matter of law of robbery. Now, whether there may have been other offenses for which he could have been indicted, tried, or convicted is another matter, but that's not the case that the state presented. This is the case the state presented, and I they have to present sufficient evidence on this charge with all of these elements, then it does do that. Before I move on to addressing one other issue that I wanted to bring before the court in today's argument, I just wanted to ask if anyone had any additional questions on that issue. The other assignment that I wanted to address was our assignment of Area 3, and that is regarding the sentencing hearing in this case. After conviction, Mr. Singleton was brought back to court for sentencing, and the state presented what rap lyrics and an allegation that Mr. Singleton had created a rap video, and that was substantially and materially important for the purpose of sentencing because it established him to be a repeat violent offender, a dangerous person to the community, and therefore that this was their justification in part by asking the court to sentence Mr. Singleton to 7 years in prison. Now, while the case was pending, trial counsel filed a motion for discovery pursuant to Criminal Rule 16, pursuant to Brady, and specifically asked for all evidence in the possession of the state, not just the prosecutor, but the state, material to either guilt or punishment. Those are the magic words. He asked for that. This information was presented to the court during sentencing. It was never provided to defense counsel. Even during the sentencing, when the prosecutor claimed he had it with him at court, it was never provided to counsel.
Did the prosecutor ever indicate when he or she received that information? I know it was like from Akron Gang Unit, but do you know when they got it?
There was nothing in the record that indicated when the prosecutor had it in his possession, when he received it from the police department.
And I guess the follow-up to that question, when there was an objection during sentencing, did the prosecutor say, oh, we just received that last night, or anything of that nature?
No, Your Honor. And in my brief, I specifically noted that the prosecutor clearly had it long enough, however long that was, to have reviewed it, studied it, and was able to quote it, allegedly, because again, it wasn't provided, so we don't know that it was quoted properly, but to be able to provide a quote to the court, so sufficiently prepared enough to quote it and make substantial argument about this information.
Had a PSI been prepared in this case?
I imagine it had, because sentencing was set out beyond the trial. I don't recall that there was a lot of in the record regarding PSI, but I imagine there was. Usually there would be in a case such as this. Counsel did object.
He did object, did he ask for a continuance of the sentencing?
I don't believe he asked for a continuance. When I read this transcript, it struck me that both counsel and client were so completely taken aback, so completely caught off guard, I mean completely ambushed is the word I would use, that I think they kind of did the best they could in the moment. I personally, in 23 years of practicing criminal defense, have never had a prosecutor pull out at sentencing documentation from a criminal investigation in an unrelated case from potentially years earlier and present it to the court without any notice or any disclosure. The judge specifically, I think, was also somewhat taken aback and said that he did consider that counsel didn't have it prior, took that into consideration, but also said it was very troubling, and then proceeded to pass the 6-year sentence. I think it is, it's hard to have confidence that had defense counsel had this information prior, that they could not have addressed it, mitigated it, been aware of it, done something with it so that the court had full knowledge of what it was or what it wasn't. Whether it was this gentleman or not involved in this, whether it was relevant or not. But under the circumstances, to present it in that sentencing for the first time on the record is wholly unfair as a Brady violation. And it really doesn't give confidence in the outcome of the sentence.
I know you looked over the screen, you're about
So just to summarize, Your Honor, Mr. Singleton was sentenced to 3 years in prison in October 2016. This is his second appeal. And he was given 161 days credit for time served in October 2016. That means by the time that this decision is released, he will have served approximately 4 years in prison or incarcerated for a crime for which, as a matter of law, the state was not able to prove all of the evidence. In addition to that, the sentencing was unfair under the circumstances. At this time, based upon the record, the briefs, and argument, we're asking that the court make a finding that the evidence is insufficient as a matter of law. Acquit Mr. Singleton of this charge. Thank you.